Just hearing there from Akash, there's three options really, although there could be more, but I mean the three main points are, yes, they agree with the Scottish Parliament and there can be another referendum. Secondly, absolutely not unless Westminster agrees. And thirdly, well, we'll have to send it back to Scotland because there isn't enough for us to judge on at this stage. Is that about right?
Yes, that's a pretty good summary, I would say.
OK, fantastic. Joe is also with us outside the Supreme Court, and we'll bring him in just a moment. Connor standing by for us as well up at Holyrood. How long will the judgment be? Quite short.
It's hard to say exactly. I mean, they reached the decision sooner than we might have expected, actually just 6 weeks or so after the hearings, when we thought it might take a few months. So that might be an indication that in the end the court has found this a simpler issue to resolve. So it might be just a relatively short judgment.
OK.
We'll find out.
And if it's kicked back, does that mean they can come again or not?
Well, yes. So there is a possibility that the Scottish Government could try and pass the legislation anyway, if the court essentially, in the way we've just discussed, declines to answer the substantive question and leaves it still in this sort of grey area.
Let's have a quick listen, should we? Because the judges are coming in now, so let's hear what they have to say. Will there be an Indy Ref 2 in October of next year?
Of the reference by the Lord Advocate devolution issues under paragraph 34 of Schedule 6 to the Scotland Act 1998.
At the outset, I should say that we are pleased that the court has been able to give judgment within a shorter time than I had indicated might be necessary. That's partly because the court is unanimous, which considerably shortens the time required, and partly because the judgment has been prioritised over less urgent matters. This is a brief explanation of the judgment handed down this morning. The full reasons for the court's decision are set out in the judgment itself. The Scottish Parliament was established by the United Kingdom Parliament at Westminster in 1998, when it enacted the Scotland Act. The Scotland Act gives the Scottish Parliament limited powers. In particular, the Scottish Parliament has no power to legislate in relation to matters that are reserved to the United Kingdom Parliament at Westminster. Those reserved matters include fundamental aspects of the Constitution of the United Kingdom, including the union of Scotland and England and the United Kingdom Parliament. Accordingly, if legislation would relate to the Union or to the Westminster Parliament, then the Scottish Parliament has no power to enact it. When the referendum on Scottish independence was held in 2014, an order in council had been made under Section 30 of the Scotland Act so as to enable the Scottish Parliament to enact the necessary legislation. The order in council amended the definition of reserved matters in the Scotland Act by providing that the reservations of constitutional matters, including the Union and the United Kingdom Parliament, were not to apply to the 2014 referendum legislation. The present case arises because the Scottish Government would like to introduce a bill into the Scottish Parliament which would provide for another referendum on independence, but the United Kingdom Government is unwilling to agree to the making of another order in council under Section 30 at the present time. So in those circumstances, the Scottish Government wishes, if possible, to hold a referendum without an order in council, and therefore without any modification of the definition of reserved matters. The Lord Advocate, who is the senior law officer in the Scottish Government, has asked this court for a ruling on the question whether the proposed bill would relate to reserved matters and therefore be outside the powers of the Scottish Parliament. The Advocate General for Scotland, who is the Scottish law officer in the United Kingdom Government, has asked the court not to decide the question on the basis that it does not fall within the scope of the procedure for referring questions to this court, or alternatively, on the basis that the court should decline to decide the question in the exercise of its discretion. The court is not asked, and cannot be asked, to express a view on the political question of whether Scotland should become an independent country. Its task is solely to interpret the relevant provisions of the Scotland Act and decide whether the proposed bill would relate to reserved matters. The court has decided that it does have the power to decide the question referred to it by the Lord Advocate. Essentially, the court has interpreted the relevant provisions according to the ordinary meaning of the words used and has decided on that basis that the provisions are wide enough to include this reference by the Lord Advocate. It's also consistent with the rule of law that the Lord Advocate should be able to obtain an authoritative judicial decision on the legislative competence of the Scottish Parliament in advance of the introduction of a bill. The court also accepts the Lord Advocate's argument that it is in the public interest that the court should decide the question referred to it. The reference has been made in order to obtain an authoritative ruling on a question of law which has already arisen on a matter of public importance. The court's answer will determine whether the proposed bill is introduced into the Scottish Parliament. The reference is not, therefore, hypothetical or premature. Turning to the question itself, the answer turns on whether the provision of the proposed bill, which provides for a referendum on Scottish independence, would relate to matters which have been reserved to the United Kingdom Parliament. The Scotland Act requires that question to be determined by reference to the purpose of the provision, having regard, among other things, to its effect in all the circumstances. Previous decisions of this court establish that a provision will relate to a reserved matter if it has something more than a loose or consequential connection with it. The purpose and effect of the provision may be derived from a consideration of both the purpose of those introducing the legislation and the objective effect of the legislation. Its effect is not restricted to its legal consequences, but can include its practical consequences. Applying that test, the reserved matters which are relevant here are the union of the kingdoms of Scotland and England and the Parliament of the United Kingdom. The latter reservation has previously been held to include the sovereignty of the United Kingdom Parliament. The purpose of the proposed bill is to hold a lawful referendum on the question of whether Scotland should become an independent country. That is, on ending the Union and ending the sovereignty of the United Kingdom Parliament in relation to Scotland. The argument presented to the court by the Lord Advocate that the proposed bill does not relate to reserved matters is essentially that because the referendum result would not automatically or directly bring about the end of the Union, it follows that the legislation does not relate to the Union. And because the referendum result would not automatically or directly bring about the end of the United Kingdom Parliament's sovereignty in relation to Scotland, therefore the proposed bill does not relate to the United Kingdom Parliament. However, as already explained, the effects of legislation for the purpose of deciding whether it relates to a reserved matter are not confined to its legal effects, but include its practical effects. A lawfully held referendum would have important political consequences relating to the Union and the United Kingdom Parliament. Its outcome would possess the authority in a constitution and political culture founded upon democracy of a democratic expression of the view of the Scottish electorate. It would either strengthen or weaken the democratic legitimacy of the Union and of the United Kingdom's Parliament's sovereignty over Scotland, depending on which view prevailed. And it would either support or undermine the democratic credentials of the independence movement. It's therefore clear that the proposed bill has more than a loose or consequential connection with the reserved matters of the Union of Scotland and England and the sovereignty of the United Kingdom Parliament. The Scottish National Party, which the court permitted to intervene in the proceedings, made further submissions based primarily on the right to self-determination in international law. They argue, in summary, that the limitations upon the powers of the Scottish Parliament, as laid down in the Scotland Act, should be restrictively interpreted in a way which is compatible with that right to self-determination under international law. The court is unable to accept that argument. The SNP rely on the judgment of the Canadian Supreme Court in a case concerned with Quebec. But in that case, the court held that the right to self-determination under international law only exists in situations of former colonies or where a people is oppressed, as for example under foreign military occupation, or where a definable group is denied meaningful access to government to pursue their political, economic, cultural, and social development. The court found that Quebec did not meet the threshold of a colonial people or an oppressed people, nor could it be suggested that Quebecers were denied meaningful access to government to pursue their political, economic, cultural, and social development. The same is true of Scotland and the people of Scotland. The SNP also relied on the submissions of the United Kingdom government to the International Court of Justice in a case concerned with Kosovo. But those submissions are consistent with the Quebec case. The government submitted that the right to self-determination under international law was normally limited to situations of a colonial type or those involving foreign occupation. That's not the position in Scotland. For all these reasons, which are set out more fully in the judgment, the court unanimously concludes that the proposed bill does relate to reserved matters. Accordingly, in the absence of any modification of the definition of reserved matters by an order in council under Section 30 of the Scotland Act or otherwise, the Scottish Parliament does not have the power to legislate for a referendum on Scottish independence. The court will now adjourn.
Okay, quick snap analysis, 30 seconds from Akash, who's been with us in the studio. Thoughts?
That's a very clear unanimous, as the President stated, decision that the referendum, as proposed by Scottish Government, cannot go ahead. This now gets kicked back into the political arena, I suspect. OK,
Conor is with us at Holyrood. No Indy Ref 2 next October, Conor.
This is probably the biggest political constitutional moment here in Scotland in very many years. Let me just remind you the main points of what Lord Reid, the President of the Supreme Court, said there. He said this was a unanimous judgment. It was in the public interest to make this ruling, which was the Scottish Government's argument all along here, and they were dealing only with the legal consequences of this. He says it was not hypothetical, it was not premature, as the UK Government tried to argue in that court case last month in London, to make a ruling on this. And he also recognised that while this legal ruling today is strictly on a legal basis, it does have wider ramifications that, of course, head into the political sphere. But he was absolutely clear, unanimous. Lord Reid said that it does meet the test of being a reserve matter, and in that case, the Scottish Parliament here behind me does not have the powers to legislate for a second Scottish independence referendum. This is a big blow to First Minister Nicola Sturgeon's case for holding a second vote on the 19th of October next year. That was the plan of attack from the Scottish National Party and from the Scottish Government, of course, who have won every election north of the border here in recent years, standing on that basis that they would be pursuing a second vote. So this will be a blow. I don't think it will be entirely unsurprising, because the Lord Advocate herself, who is the top law officer, law advisor to the Scottish Government, said that she couldn't make this ruling, and that is why it was sent to the Supreme Court. So probably not entirely surprising. However, it will be disappointing for Nicola Sturgeon and her Scottish Government. What happens next is absolutely crystal, you know, one to be determined in the coming hours. Nicola Sturgeon has been saying all along that if the court made this judgment that it was not within the competence of Holyrood here to rule on that, then she would use the next general election as a de facto independence referendum. Now, opposition politicians have been saying that they would not go along with that, they would not play ball with that. So it'll be very interesting to see in the coming hours what exactly both sides of this debate have to say, because this independence question, whatever way you come down on the issue, whether it's yes, no, unionist or nationalist, is absolutely through every aspect of issues that are debated here at Holyrood, whether it be the National Health Service, whether it be the Education Service. The issues on both sides are intertwined, and it will be very interesting to see exactly what happens in the coming hours. But a crystal clear argument and case there from the Supreme Court that Holyrood does not have the power to legislate for a second Scottish independence referendum without Westminster's consent.
Stand by, Conor, if you would. Akash still with us here in the studio. Suggestions there, as we heard from Conor, that the next general election could be a referendum on independence. Would that be legal?
I mean, I think that it's not a question of whether it's legal, it's a question of whether that has any meaning. Nicola Sturgeon, yes, back in June when the Scottish Government published its plans, said that if they lost the case, the SNP would fight the next election as a de facto referendum. But that's just a piece of political rhetoric. I mean, a UK general election is an election to determine the membership of the House of Commons, to determine which party or parties forms the government of the United Kingdom. One political party claiming that it is a referendum on a particular issue does not change the constitutional fact of what a general election is. So, Conor, that's what we might hear from Nicola Sturgeon later on, but a general election is to elect people to the chamber of the House of Commons, and she just can't make it into a referendum just because on independence just because she wants to.
Nicola Sturgeon's counter-argument to that point, Kay, would be that she has stood on a platform at every single election over the course of the last couple of years on the basis that she is asking people to vote for a party who are standing on a platform of independence. And she will argue in the coming hours, no doubt, that if the court is saying on a legal basis that this place, Holyrood, cannot legislate for a second Scottish independence referendum, and you've got a situation where the Prime Minister, successive Prime Ministers, Boris Johnson, Liz Truss, and most recently Rishi Sunak are saying, look, now is not the time for that second independence referendum, then what is the democratic route for Scotland to decide its future? Because the majority of MSPs in this place were elected on the basis that they want an independence referendum. So this will trigger yet more political debate, more political row, and really we're no further forward after that very crystal clear ruling from the Supreme Court.
Indeed. So Joe Pike is outside the court for us now. I mean, it seemed pretty clear-cut from the moment Lord Reid sat down that this is what he was going to say. Joe, what did you think?
I think there will be relief, perhaps on both sides, that the first hurdle was clear, that actually the court could decide on the substantive issue of whether the Holyrood Parliament can have a referendum without Westminster's approval. I think there will be relief and delight in the Scotland office and in Number 10. Rishi Sunak has been paying close attention to that, and part of his preparation for Prime Minister's question today has been getting an answer on the issue of Scotland, trying to get the tone right and not to, as some unionists would worry, let this moment become a moment of momentum, of galvanising support for Scottish independence for the SNP. There is an opportunity here for the SNP, even though they have lost. I think on the SNP side, for Nicola Sturgeon, for the Scottish Government, it is difficult to work out where next. It is a clear setback. Yes, she's talked about using the next UK general election as a de facto referendum on Scottish independence, but within her party, a lot of people who don't think that's a great idea because they think it's possible she will not get 50% of the vote. So a consequential, clear decision for the Supreme Court. It means that we're not going to have another hearing here in a year or two's time. It's not going to be sort of wrangling again and again and again. This is settled for now. The route to getting Scottish independence now seems pretty unclear, and that, the SNP argue, is unfair. There should be a mechanism, especially if support for independence grows. But I think a victory today for the UK government that they, Kay, will be very relieved about.
OK, Joe and Conor, thanks very much indeed. Final thought from our devolution and independence expert, Akash Pound. Is there any point in the Scottish Government appealing this decision?
There isn't any route to appeal. The Supreme Court has made its decision. It's made it very clearly. There's no higher court to which this issue can now be taken. So unless the UK government, UK Parliament, at some point accepts the democratic case that Scotland should have a referendum and passes the necessary legislation, as your correspondents have just pointed out, it's quite hard to see what the route ahead will be for the SNP.
OK, thanks very much indeed for your expertise. Thank you. So, tuning our way, let me tell you that there will not be a Scottish independence referendum next October, as had been hoped by Nicola Sturgeon. She says, OK, if that's the case, when the next election comes, whenever that might be, I will use that as an independence referendum. We're just hearing from our experts here. She can say what she wants. That's not going to be the case. Ian, I wonder whether that's going to have any impact on the markets this morning. Good morning to you.
Thank you, Kay. Well, I think that remains to be seen. But in the meantime, welcome to Ian King Live, an hour of business and economic news from the heart of the city. And we begin this morning with the latest PMI data, which has been published in the last half hour. It's one of the more reliable indicators of the state of the economy, and it shows that UK economic activity continued to contract in November as orders decreased and employment growth slowed. Well, with any reading above 50 representing growth and any reading below that a